let's go and get started. Let's put phones away. So I don't have any papers to hand back. We are very close on paper number 1. I was hoping to get those back today. I think those grades will get posted today, but they're just not quite ready. If anybody's super eager to get that paper back, you can come by office hours later or shoot me an email, but otherwise I'll hand it back on Tuesday. And I'm hoping that we'll have paper 2A back on Tuesday as well. As of now, paper 2B is due a week from tomorrow. That is what it says on the syllabus. Plan on that being still the due dates. A couple people have asked whether I'm pushing that back since I pushed 2A back. I'm still thinking about it. So as of now, that's still due a week from tomorrow, and we'll get the one-pagers back to you with some feedback on Tuesday. But if I push that back, I'll let you know. And so I encourage you not to wait, right? Obviously, the feedback that we give you on the one-pager is meant to be helpful on the longer version, but I encourage you not to wait for that feedback. You should continue doing what you're doing to prepare the longer 5-page paper. Questions about that? Okay. So take a look at your handout and read the first 2 paragraphs. We're reading the first 2 paragraphs on the handout. We're reading the first 2 paragraphs. All right, so this is a long quotation from Justice Blackmun's opinion in Roe versus Wade in 1973. What's going on in these first 2 paragraphs? What's Blackmun talking about here? Yep.
I'm saying that although the right to privacy is not explicitly stated in the Constitution, it's implied by either combining several of the amendments or just little pieces of the first, fourth, and fifth.
That's a good start. Right to privacy is not in the Constitution itself, but there are some other amendments, some other provisions that are in the Constitution that maybe suggest or imply a right to privacy. Which specific ones did you mention? The first and the
First, fourth, and fifth.
Okay. Which other ones does Blackmun mention?
The 9th.
9th. Yep. And what else? 14th. Yep. And which one seems like it's most important for him?
14.
How do you know?
He's talking about the section of liberty and what falls under that liberty.
Yep. So, what's the last thing you said?
That were granted, like what falls under the liberty that was granted in the 14th Amendment.
Yeah. So 14th Amendment due process clause says no state shall deprive anyone of life, liberty, or property. without due process of law. And he seems to be saying that maybe the concept of a right to privacy is included within that word liberty. But again, the Ninth Amendment says, what's the Ninth Amendment say? Somebody? What's the Ninth Amendment say? Better pull out those pocket constitutions. Nachman? Yeah. Remember, so back at the beginning, right, the original Constitution didn't have a Bill of Rights, and some people complained and said, oh, one of the things we need to do is add a Bill of Rights to it. And some of the authors of the original Constitution, including James Madison, are like, no, we shouldn't do that. We don't want to add a Bill of Rights, because if you try to list the rights, you're inevitably going to forget something important. And if you put a list in there, then anybody later on who looks at the list is going to say, well, obviously, right, the marriage or whatever is not on the list, so that must not be protected, right? Anything, if you make a list, it implies that the things that aren't on the list are not included, right? That's the point of a list. And so they were smart. They said, okay, well, we still want the list, but you're right, we might forget something. So let's say explicitly, the enumeration in the Constitution of certain rights shall not be construed, that's like a command to future constitutional interpreters, shall not be construed to deny or disparage other rights retained by the people. So that seems important. Seems to say directly that there are some other fundamental important rights retained by the people that are not mentioned in the constitutional text. And what about the First and Fourth Amendments? Those guys, how are those relevant to a right to privacy? Yeah.
First Amendment, or Fourth Amendment, sorry, with surveillance and spying. So.
Yeah. Fourth Amendment doesn't have the word privacy in it, but it seems to be about something that is related to privacy. Right? The right of the people to be secure in their persons, houses, papers, and effects. Right? No unreasonable searches and seizures. If they bust into your house and search through all your stuff with no good reason, that seems like an invasion of your privacy, among other things. How's the First Amendment relevant?
So the First Amendment says Congress make no law restricting the right of the people to peaceably assemble. That also includes like associations, so like to be in relationships with somebody. The government can't come in and say, you are not allowed to be with that person, you are not allowed to have your own. Like that.
Yeah. Freedom of association is another right that is not explicitly mentioned in the Constitution itself, but the court in various cases has said, yeah, but if you have the right to free speech and you have the right to peaceably assemble and petition the government, that's not about like one guy doing all that. That seems to suggest that you have the right to join together with other people, right? Other like-minded people join together, form some kind of group to go petition the government for a redress of your grievances. And so association, the right to associate with other people of your choice without interference by the government, seems like it's implied maybe by that text in the First Amendment. Right to privacy seems like it's still a little further step. Like what exactly does that have to do with privacy? I guess you have the right to associate in private, right? The government shouldn't be like busting in your house to like figure out who you're like meeting with and discussing politics with. So that's got something to do with privacy. Might be a little more of a stretch there, but and we said, so there's a whole bunch of, there's nothing in the Constitution that says right to privacy, but there's a whole bunch of provisions that might have something to do with a right to privacy. We said it seemed like it's the 14th Amendment that's most important for black men. How do we know that from these two paragraphs? Nothing?
Should be secure on life, liberty, property, without due process of law.
Yeah, so that's what the 14th Amendment says, and that sounds important, but how do we know that that one's important for black men? Like he's mentioning multiple different provisions of the Constitution here. They all must be important in some way, but I'm suggesting that one of them seems more important.
It says the right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty and restrictions upon state actions as we feel it is. So he's saying, he's like singling that one out, like this court has decided that the 14th Amendment is more important for deciding this issue.
That's right. He's mentioning multiple rights, but he's pointing to one of them and saying, this is the one that we really think is the key one here.
I'm guessing it's because the Bill of Rights, the first and the fourth, applies to federal action, and he wants to be able to enforce it at a state level.
So that's part of the story, right? The 14th Amendment applies to state governments. The original Bill of Rights apply only to the federal government, although this is 1973, and by this time the Supreme Court has held in a series of cases that almost all of the original provisions of the Bill of Rights should be understood as included within, incorporated within the word liberty in the 14th Amendment, so they apply to the states too by this point. But the 14th Amendment is clearly important for him, right? He mentions multiple provisions of the Constitution, but he says, and this seems like some people when they read it at the time and still today are like, this is kind of a weird way for the Supreme Court to put it. Like, could they make up their mind or not? Like, where, like, do we have a constitutional right to privacy? And if so, where in the Constitution does that come from? He's like, well, maybe it comes from the 14th Amendment, or maybe it comes from the 9th Amendment. That seems like a little bit of a strange way to put it. Like, but he does say, well, whether it comes from the 14th Amendment, as we feel that it does, right? He's not leaving it totally up in the air. He's like, we think it's here. One of the reasons he's also mentioning the 9th Amendment is because that's what one of the lower courts in the case had emphasized, right? So whether we found in the 14th Amendment as we feel it is, or as the district court determined in the 9th Amendment. So like, the district court had a different constitutional argument here. We're not going with that one, but we're acknowledging it and saying we understand the line of thinking there too. We're just adopting a different argument here. Right? So there is no right to privacy mentioned in the Constitution, but there are multiple provisions that, depending how you read them, maybe could be thought to imply at least some components of a right to privacy. And we think the most important of those provisions is the guarantee of liberty in the 14th Amendment Due Process Clause. And we believe that word liberty includes a right to privacy. Read a little bit further. Read the next couple paragraphs. All right, that's probably good. And actually, jump back up to the first paragraph for a second. There's one other thing I wanted to flag there. What the very end of that first paragraph? What is that? What is he talking about there? Like the last two sentences. Last two sentences of the first paragraph. What's Blackman getting at? I'm going to wait till I hear from somebody I haven't heard from yet. Yeah.
Griswold,
Yeah, what about it?
in that case,
they were doing something, I forget what it was exactly, something with like, it's along the lines of birth control.
That's right. There was a law banning the sale and possession of contraceptives.
Right, and they deemed that it was within the personal privacy of that marriage that they could try to do stuff along the lines. I'm not too read up on that case, but something along the lines of like personal privacy even within marriage.
Sure, that's a good start, right? So Griswold was filed by a married couple in Connecticut. Under Connecticut, nobody was lawfully allowed to use contraceptives under Connecticut law, right? And this particular case was filed by a married couple who obviously are saying that they want to engage in sexual activity without getting pregnant. And so they want to use contraceptive devices, which is illegal in the state of Connecticut. And the court rules that that law violates their right to privacy, right? So Roe v. Wade is not the first case where they're talking about right to privacy, right? There are earlier cases. Griswold is one of them. What else are these two sentences here about? Yeah?
I think they're trying to cover a lot of their bases so that they don't keep hearing like the same cases. They're saying that all these things follow under personal privacy. So
And what kind of things?
like relationship within a family or their children. I think it's interesting that education's in there because they're seeming like it's a personal choice how you educate your kids and your family.
Yeah, yeah. So he's making a couple points here, right? And they're important for Roe versus Wade, right? So Roe versus Wade is about the right to terminate a pregnancy, which is obviously not explicitly specified in the constitutional text. And he is pointing out that there are other provisions in the constitutional text which are kind of broad, abstract guarantees of liberty in some way or another. And over time, we've had to figure out what exactly kind of things they apply to. And we have a whole bunch of prior decisions in which we have said that some specific liberty that is not itself mentioned in the constitutional text is somehow included within or implied by these other liberties that are mentioned in the constitutional text. And in fact, if we go back and look at all these precedents, and if you read this in the original Supreme Court opinion, not the excerpted version I've got for you here, after, like by every one of those semicolons at the end of the first paragraph, there's a citation, right, to a previous decision. Right? So he says there's all these previous cases where we have held that this fundamental guarantee of liberty and privacy applies to activities relating to marriage, and there's a citation to a case. Procreation, and there's a citation to a case. Contraception, there's a citation to Griswold. Family relationships, there's a citation. Child rearing and education, there's citations for each one of those. None of those specific liberties are protected in the constitutional text, but we have protected all of them. Right? So he is partly making the general point that we've got a long history of protecting unwritten constitutional liberties, and he is partly making a more specific point about some of the kind of areas of human life in which we've particularly been willing to do so have to do with marriage and procreation and the like. And so reasoning by analogy, the right to choose whether to bear or beget a child, right, is going to be included in that list. All right, so jump down now to like the third and fourth paragraphs. What's going on here? Yeah.
It looks like they're kind of outlining what term will be agreed upon for kind of constituting when a child will be protected or a fetus will be protected.
When you say term, what do you mean?
Kind of like at what point, at what stage in the pregnancy, rights and protections will be given to the unborn child.
And why would he do that?
Because he wants to have an opportunity for, well, first off, it's probably popular, kind of the popular opinion at the time.
Okay, maybe, yeah.
Second off, it like allows for interpretation in the future, I suppose, on specific cases.
Okay, so that's a start. Yeah?
I was going to say more broadly, I really like this last line where he says, important legitimate interest in potential life, the compelling point. These three words are all words we used last class to talk about at what point the government is allowed to infringe upon a right, or what sort of, I think we use the word scrutiny, is applied in determining whether or not the government has that capability.
That's a good point, right? So the first two paragraphs here are making the case that there is such a thing as a right to decide whether to give birth, or a right to decide whether to terminate a pregnancy. Like, that is not mentioned in the constitutional text, but the point of those first two paragraphs is to connect it to other kinds of unwritten rights that the court has previously protected. And now he's shifting gears, and now he's talking about the circumstances under which this right could be limited, right? Because no rights are absolute. Freedom of speech is not absolute. Freedom of religion is not absolute. None of them are absolute, right? Prohibitions against racial discrimination are not absolute, right? The court always uses this kind of language of like, well, okay, we got an important right here, but also the government's got some really good arguments for why they say it's necessary to restrict the right in this instance, national security restrictions on free speech or whatever it might be. So what do we do? Well, there's going to have to be some effort to weigh those things against each other. How important is the right, and how important is the government's reason for restricting it, right? And so when you see those words like, where's that sentence you were just pointing us to?
That's the very last sentence on the page.
With respect to the state's important and legitimate interest in potential life, the compelling point is that viability, right? So, so back up a little higher for a second. In the third paragraph, we do not believe, this case was from Texas, it was about a Texas law that imposed a criminal ban on abortion with no exceptions unless the mother's life, the pregnant woman's life, was immediately threatened. We do not think that Texas may override the rights of the pregnant woman that are at stake. However, the state does have an important and legitimate interest in preserving and protecting the health of the pregnant woman, right? Abortion is a medical procedure. Obviously, medical procedures can be regulated by the state to make sure they're done safely. And that it has still another important and legitimate interest in protecting the potentiality of human life. Right? So there are two different interests. The health of the pregnant woman and the life or potential life of the fetus. Two different interests that might justify restrictions on the right. Right? And the rest of the opinion is going to be an effort to try to come up with some sort of approach to balancing these important governmental interests against the woman's constitutional right. Right? And so take the health of the pregnant woman first. What is the balance that Blackmun comes up with for that? When and how is the state allowed to regulate abortion in order to protect the health of the pregnant woman? Jack?
He quotes some sort of medical fact that
Yep.
there's a certain point in rearing the child to where if you were to abort after that point, the chance of the mother dying is higher than if you were to just give birth, is essentially what he says.
Yep.
Until the end of the first trimester, mortality in abortion may be less than mortality in normal childbirth. So,
First trimester abortions are routine medical procedures, very low risk. In fact, lower risk than childbirth. Right? Women sometimes have medical complications in childbirth and sometimes die. Right? Less often than used to be the case. Less often in developed than in developing countries, but it still sometimes happens. Right? And a first trimester abortion is safer than childbirth. And so, if you are talking about regulations designed to protect the pregnant woman, a regulation that prevented her from having a first trimester abortion and forced her to carry the fetus to term, could not rationally really be justified as an effort to protect her because you are making her do something that is more dangerous, right? And so in the first trimester, it doesn't make any sense to allow the state to regulate abortion on these grounds. After the first trimester, abortion, you have to use different procedures to perform an abortion, and they are more complicated, and they are higher risk. And so maybe it's justified there. Right? What? Like, none of that is in the Constitution, obviously. What the heck is all this? Like, Blackmun is attempting, he said we got a constitutional right here, but we also have some important state interests for regulating the constitutional right, for putting limits on it, and I am trying to balance them. And what I have come up with is this trimester framework, that the balance should be struck differently at different points in pregnancy. Right? So first trimester, no regulations justified on health grounds. Second and third trimester, regulations justified on health grounds are fine. Colin?
I'm not sure I'm going to get to the question that I want to ask in the right
Yep.
wording, but do you, so at this point, we've seen in the Supreme Court's history that they seem to recognize that, like, in perfect harmony, executive, legislative, and the judiciary work together to support each other, and that strengthens each individual entity's, like, goals. Do you think that some of the language, like, well, especially, like, compelling and, like, with all deliberate speed, do you think that erode? We've seen that the Supreme Court has trouble enforcing kind of the laws that they make. Does that erode the legislative body's ability to support? Because like when they use vague language like compelling or like with all deliberate speed, it kind of creates a situation where people don't necessarily listen or have different interpretations of this kind of weaker language.
So let me see if this helps.
Yeah.
I think this might help. We'll see. So this was the court's most controversial decision it had issued in 20 years, right, since Brown versus Board of Education. And we know that Brown versus Board of Education was quite controversial and was not fully complied with because lots of people disagreed with it and they didn't want to comply with it. Same thing happened here. Super controversial, lots of people disagreed with it, and they didn't want to comply with it. And just like you had local school districts trying to maintain segregated schools long after Brown versus Board of Education, you had state governments, especially, occasionally Congress, but mostly state governments, trying to impose strict restrictions on abortion long after Roe versus Wade, right? And so part of the premise in your question is for sure absolutely correct, right? The Supreme Court sometimes issues decisions that are highly controversial and there's problematic patterns of compliance. I don't know, I think it's something worth thinking about. I don't know the answer. Whether the court's specific wording in the opinions plays a huge role in that controversy, right? I mean, white Southerners who are committed to segregation didn't care that much about the specific wording in Brown versus Board of Education or Brown 2.
But then they have
Right.
precedent that's established in doctrine that says, oh, okay, we have like a get out of jail free card as far as this is concerned.
So all deliberate speed certainly was read as a signal that some kind of foot dragging would be tolerated. I'm not sure exactly what's the comparable language here. Again, I don't know why so here's what it looks like from the court's perspective, right? The court's like, we're not just trying to tell everybody what to do. That's not what we're about. Our job is to protect the Constitution. 14th Amendment says no state shall deprive anyone of liberty without due process of law. We got a long history of decisions. I'm going to tell you a little bit more about some of those prior decisions. But we got a long history of decisions saying, is a right to marry included within the word liberty? Yes, I think it is. Is a right not to be sterilized against your will included in that word liberty? Yes, I think it is. Is the right to use contraceptives without interference by the government included in that word liberty? Yes, I think it is. And now here today, is a right to terminate a pregnancy included in that word liberty? Yes, I think it is. So that's what they're doing. But we recognize that lots of people disagree with this. And we're not trying to say the government's never allowed to regulate abortion at all. We're trying to come up with some kind of balance, right? This is what the court is wanting to do. Whether it works or not is a good question. We want to come up with some kind of balance. So the language about what kind of compelling governmental interests there are That's an effort to acknowledge that the protection of the health of the pregnant woman and the protection of the potential life of the fetus are really important, and sometimes would justify government restrictions on abortion. And so we are going to try to come up with a legal framework that helps give some guidance there. Right? Is the guidance crystal clear? No. Is the legal framework somewhat arbitrary? Like, what the heck? Why the first trimester? Like on the end of the last day of the 13th week or whatever, state's not allowed to restrict your abortion, and then on the first day of the 14th week, the state is allowed. What the heck is that? That's not in the Constitution. They're just making that up. Yes, they're just making it up. But the reason they're making it up is because they are trying to say that there are important things on both sides here, and they're trying to figure out some way to balance them. Does that help with your question at all?
Yeah, I think that some of the wording that we've seen, it just erodes that, it just makes it more difficult for the court to, not that the court necessarily wants to enforce the rules that it makes, but in a perfect world there wouldn't be a terrible amount of questions that arise or circumstances that arise where people don't follow the court's legislation or the court's decisions on legislation.
And so with Brown, I think I'm following you. If they had left out that all deliberate speed part, I could see how things potentially could have been different. But what should be left out here? What would be the different wording is what I'm not clear on.
I guess they're just defining compelling there. It's establishing it as a word.
I mean they could say this would be clearer, and you could say this for any constitutional right. You could say, make no law means make no law, absolutely no restrictions on freedom of speech whatsoever. That is clearer. It's also stupid, right? What really? Does anybody want to live in a society where no possible thing that somebody utters in public could ever be punished by the government? That would seem to it would cause some problems, right? It would be clearer, though, And so they're reluctant to do that. They don't think the justices of the Supreme Court, none of them, really, even though Black used to kind of say this on the First Amendment, but none of them really think any constitutional rights should be absolute in all circumstances. And then you're in less clear territory, because then you're trying to draw lines. Which kinds of racial classifications in the law definitely violate the 14th Amendment, and which kinds don't? And how about gender? Which kinds of gender classifications in the law definitely violate the 14th Amendment, and which kinds don't? If you are not saying all of them violate it, then you're trying to draw some lines, and it's less clear. So one line Blackman draws is, for the first third of pregnancy, abortion is safer than childbirth. And so there's no justification at all for the state to regulate abortion in the name of protecting the pregnant woman's health. But what's the other line? Right? The other state interest is in protecting the life or potential life of the fetus. That's Blackman's phrase that he uses several times in the opinion. The life or potential life of the fetus. It's an effort to avoid deciding. Right? The court doesn't, that's a religious question. When does life begin? We're not going to weigh in on that. Whether it's a life or a potential life, the government has some interest in protecting it. How do we draw the line on that one? This is down towards the bottom of the page. And then over on the next page. When is the state allowed to regulate abortion in the name of protecting fetal life? I'm going to wait for someone over here.
Viability.
Why?
Because theoretically, if the baby is viable, it then no longer is a potential life. It's a life because it's able to live outside the mother's womb.
Yeah. The word viability means able to live on its own outside the womb. And so if you are at the point in pregnancy where if delivery occurs, the fetus can survive, Blackman's that seems to me to be a reasonable point at which we might say the state could now ban abortion. Right? They could regulate it or even ban it, he says. Right? This is now not just a potential life. This is a separate, the state could reasonably conclude that this is now a separate human being that can survive on its own, and so abortion should no longer be permissible. Before that, is it in some ways a separate human being? Yes, but it is not a separate human being that can survive on its own without being connected to the mother's body. And so the balance shifts at that point. Blackman says, post-viability, once the fetus can survive on its own, the state is free to regulate abortion in the name, on the grounds of, in pursuit of, protecting the life or potential life of the fetus, and regulating and even banning abortion, provided, and this is important, this is the very end of the quote there, except when it is necessary to preserve the life or health of the mother, right? So and the approximate point of fetal viability is the beginning of the third trimester. So that's how we wind up with the trimester framework. We've got 3 different periods of pregnancy with 3 different rules. In the third trimester, post-viability, the state is free to ban abortion, provided that there are exceptions in place for when the abortion is medically indicated, right? If the doctor says, if you deliver this child, you're going to die, or there's going to be a significant threat to your health, I recommend that we terminate the pregnancy, then the state has to allow that. But in the absence of those exceptions, the state can ban it, right? So the result here is that in the first trimester, pregnant women have a more or less complete constitutional right to abortion. States should not be interfering with it at all. In the second trimester, states are free to impose regulations on the practice of abortion that are designed to protect the health of the pregnant woman. And in the third trimester, states are also free to impose regulations that are designed to protect the life or potential life of the fetus, including bans. They want to ban it altogether in the third period. Yeah.
So does this make it more difficult in cases of like sexual assault?
So there is nothing in here, in Blackman's opinion, about abortions that result from rape, pregnancies that result from rape. I can tell you what state laws at the time said. As of the mid-1960s, abortion was illegal in all 50 states, mostly without exception. Right? Exceptions, usually a narrowly written exception for if the pregnant woman's life was threatened. Right? If her life is in jeopardy, then you can terminate the pregnancy. Otherwise, abortion is completely illegal. In the mid-late 1960s, early 1970s, 4 states, including New York, legalized it. Right? The state legislature passed a law. Right? Reproductive rights advocates were lobbying the state legislatures. They passed a law. Four states legalized it, and 13 other states created some narrow, expanded the still narrow, but some list of exceptions where it would be allowed, and some of these included instances of rape. Right? So as of 1973, there were 4 states where abortion was legal, and 13 others where it was legal in some circumstances. Most of those 13, all of those 13, I think, said if there's a significant threat to the pregnant woman's health, then abortion is legal. And some of them also said if the pregnancy resulted from rape and the woman chooses to terminate it, then it's legal. But in the other 33 states, including Texas, it's still criminalized basically without exception, right? And so Blackman's opinion doesn't say anything about pregnancies that resulted from rape, but of course the logic of the opinion is, like, any woman now has a constitutional right to terminate a pregnancy in the first trimester, right? So a woman who is pregnant as a result of rape could terminate the pregnancy in the first trimester as a result of his opinion. Yeah.
In those states, did they use like the trimester logic? Like, was it abortion at any point, or?
I don't think, I couldn't swear to this, I don't know the details of all 50 laws, but I don't think any of them use the trimester framework, and I don't, for the most part, they were not focused on different stages of pregnancy. They were focused just on the reasons for the abortion, right? So like they all said, all 50 states said, if the pregnant woman's life is immediately threatened, the doctor can say, we're going to terminate this pregnancy. And that could happen at any point, right? Sometimes that's something you just, if the woman's got like a heart defect and got pregnant unintentionally, and a doctor had already told her, no, you can never deliver a child safely with this heart defect, then they could terminate the pregnancy early, or if they didn't discover the heart defect till later, then they could terminate it late. It's not focused on the stages of pregnancy. That is really introduced by Blackman, and it's one of the controversial aspects of the opinion, right? And we are going to see another example of this next week when we talk about Miranda versus Arizona, where the Supreme Court writes this whole thing, right? Cops, if they arrest you, they suspect you of a crime, they got to say you have the right to remain silent, you got the right to an attorney, if you can't afford one's going to be provided for you. That whole thing is written by the Supreme Court in Miranda versus Arizona. They actually got the words from somewhere else, which we'll talk about, but none of those words are in the Constitution. Some of them are connected to some words in the Constitution, but it's like the court is not just saying in these cases, here's something the government's not allowed to do. It is like taking an additional step of spelling out a whole kind of framework to guide everybody in knowing what things the government's allowed to do and what things it's not allowed to do, and when it's allowed to do them and when it's not allowed to do them. And that, some people say, is like stretching the bounds of the court's role. Like, it sounds like, some people say, it sounds like the court is kind of like making up the whole abortion law for the whole country, like it is writing like an abortion statute. Is it interpreting the Constitution, or is it writing an abortion statute, right? And Blackman's defense would be, we're just interpreting the Constitution, that's what we're trying to do, but unless you want us to say it is absolute without exceptions, we got to come up with some kind of legal guidance for people so they know what's allowed. The states all want to regulate abortion. We got to give them some kind of guidance. What kind of regulations are consistent with the constitutional requirement and what kinds aren't? That is what we're trying to do. Okay? So that's the opinion of Roe versus Wade, right? One of the most famous opinions in the court's history. It's obviously longer than just this one page, but these are like the key passages from it. I want us to think about it in kind of two directions. Like first, like back up a little bit and talk a little bit more about stuff that was happening before Roe versus Wade to help understand how this fits in with prior things that the court has done. It's not just out of the blue. And then talk about what happens after the decision and how the court tries to apply this trimester framework to different issues that come up. We've got time for both of those things. So if you took Con Law 1, you'll remember we talked about multiple examples in which the court indicated a willingness to protect constitutional rights that were not written in the constitutional text. The first one that we talked about was from 1798. That is a long time ago. That is before Marbury versus Madison. Right? The court said, yeah, well, yes, right, some fundamental rights are not specified in the constitutional text, and of course we would still protect them. There are certain vital principles in our free republican governments which will determine and overrule an apparent and flagrant abuse of legislative power. An act of the legislature, for I cannot call it a law, contrary to the great first principles of the social compact, cannot be considered a rightful exercise of legislative authority. And then they go on to give a whole bunch of specific examples, none of which are expressly mentioned in the constitutional text. Right? If a legislature passes a law that violates fundamental rights as fundamental rights that are clearly components of our national legal traditions, we would not allow the legislature to do that, whether or not the specific right is written down somewhere. Right? We talked about some examples from the early 20th century. Meyer versus Nebraska, which was about the right to teach and learn foreign languages. That was the law that said you weren't allowed to teach anybody German. Pierce versus Society of Sisters, the right to send your kids to private school, like the right of the parents to control the care and upbringing and education of their children, is how the court would put it. But the law at issue was a law that banned private schools. Right? The court says those rights are protected, even though they're not mentioned in the constitutional text. The lawyer's term for these kind of rights is unenumerated rights. Which is just a fancy way of saying unwritten rights. And one thing to note about these cases is that these rights that the court is protecting in Calder versus Bull and Meyer versus Nebraska, Pierce versus Society Sisters, they're not really unwritten rights. I mean, they're from one angle they're unwritten rights, but from a different angle they're not unwritten rights, because in every one of those cases the court talks about some provisions of the constitutional text, some things that are written in the constitutional text. This specific right does not appear in the constitutional text, but the argument is that it is connected to something that is in the constitutional text. So it's not like the phrase sometimes leads you to think like, oh, the court is just making up rights that don't have anything to do with the constitutional text. That's not quite right. The court is starting with provisions in the constitutional text and then trying to figure out what is fairly included within them. And that sometimes leads them to more specific rights that they say are protected. And the more specific right is itself unwritten. Right? So the right to teach and learn a foreign language is included within the liberty guaranteed by the 14th Amendment Due Process Clause. That word liberty is in the constitutional text. Right? Second point about these unwritten rights, unenumerated rights, one that Blackman makes in Roe, is that a lot of them seem to have something to do with the category of marriage, procreation, childbearing, child rearing, right? Whatever that category is called, right? Family, sexual activity, childbirth, child rearing. A lot of the court's unenumerated rights decisions seem to come from that arena, right? And the court has repeatedly held that some such rights are fundamentally important and guaranteed by the Constitution, even though they themselves do not appear in the constitutional text. In Skinner versus Oklahoma, in 1942, Supreme Court struck down a compulsory sterilization law from Oklahoma. If you took common law 1, you'll remember that the Supreme Court upheld a compulsory sterilization law in an earlier case, Buck versus Bell, from 1927. But in 1942, the Supreme Court reverses that. Oklahoma passed a law that said if you get convicted of 2 or more felonies involving moral turpitude, the state would sterilize you against your will. And there was a list in the law of felonies that didn't count, like most white-collar crimes were excluded from the law, like embezzlement was not, like that's okay, you can do that a few times, and we're not going to sterilize you. This guy, Mr. Skinner, gets convicted of stealing chickens, and then some other similar crime, and the state says it's going to sterilize him. And he gets a lawyer, he goes to the Supreme Court, and he wins. The Supreme Court says you can't do that. Right? The right to procreate is a fundamental constitutional right. The Supreme Court, one of the things they emphasized in the opinion, Justice Douglas wrote the opinion, one of the things he emphasized is kind of an equal protection thing. Like, come on, chicken stealing, you get sterilized, but embezzlement, you don't get sterilized? What's up with that? Like, that seems like unfair discrimination. But he also emphasized that this is, even if it applied to every crime equally, this would still be a problem, because the fundamental right to procreate is a fundamental right. Right? Justice Stone wrote a concurring opinion. This is 1942. So it's 4 years after Caroline Products and the famous footnote. Justice Stone writes a concurring opinion, and he cites his own Caroline Products footnote opinion in there, and he says, the real question we have to consider here is not one of equal protection, but whether the wholesale condemnation of a class to such an invasion of personal liberty without any opportunity to any individual to contest that decision satisfies the demands of due process. It's about a guarantee of liberty under the Due Process Clause. Right? Right to procreate is a fundamental aspect of constitutional liberty. In the late 50s and early 1960s, the birth control movement starts trying to extend these decisions to laws that regulate contraceptives. Griswold versus Connecticut is the famous case. That was actually at least the third attempt by birth control advocates in Connecticut to persuade the Supreme Court to strike down Connecticut's criminal prohibition of contraception. The first case was brought by two law students. It was a married couple, straight married couple. They were both students at Yale Law School in Connecticut. And they found a lawyer and they went to court and they said, look, we are married. We are engaged in sexual activity. We want someday to have children. But we are both currently in law school. Now is not the time at which we want to have children for obvious reasons. Right? What would in practice have to happen is the mom would have to drop out of law school. Right? We don't want to get pregnant. We want to use contraceptives. Supreme Court ducks that case. They dismiss it on some kind of technicality. The birth control advocates recruit some other people to come back with another challenge. In a case, I forget what that first case is called. The second case is called Poe versus Ullman, and the Supreme Court ducks that one too. Right? They're just not eager to decide the case. And they try a third time, it comes back in Griswold versus Connecticut, and the Supreme Court strikes the law down. And if you read Justice Douglas's opinion in Griswold, you can kind of get a sense of why maybe they weren't eager to decide it. Because Justice Douglas is clear that he thinks this law is unconstitutional. Right? Well, come on. Right? A complete criminal prohibition on the use of any contraceptives throughout the state of Connecticut? That sounds like it better be unconstitutional. Right? Justice Douglas is clear that it's unconstitutional, but he is struggling in Griswold versus Connecticut to articulate why. Because there is no provision of the Constitution that directly seems to cover it. And what he comes up with in Griswold versus Connecticut is an opinion that is usually described as a somewhat tortured and not very persuasive effort to justify the court's protection of right to privacy. Most people nowadays don't object to the court protecting the right to privacy. Most people think that's the right decision. And there are lots of subsequent opinions that come up with more persuasive arguments for it. And in fact, there's a concurring opinion in this case that comes up with a more persuasive argument for it. But Douglas's argument, in the court's majority opinion in Griswold, is usually described as not that great. Because, and it's a little bit like Blackmun's opinion in Roe, but worse, I think. He says, if you read it, he's like, well, look at all these different provisions of the Bill of Rights. The First Amendment and the Third Amendment, that one's about quartering of troops, right? The Fourth Amendment, unreasonable searches and seizures, and Fifth Amendment, Sixth Amendment. He mentions almost all of them, right? Look at all these different provisions. None of them say privacy, but the specific provisions in all these different amendments have penumbras and emanations. Penumbra is a fancy word for shadow. The specific rights guaranteed in the Bill of Rights have shadows and emanations that extend more broadly than their literal words. You can see what he's driving at. Is that the best they can come up with? Right? Some people's reactions are like, that doesn't seem that persuasive. Wait, the amendments have shadows? What the heck does that mean? Like, what is the shadow of the Fourth Amendment? And how does that cover? Obviously, the Fourth Amendment has something to do with privacy. It says that the police can't bust into your house without a warrant. So if they don't have good reason to believe that you're engaged in criminal activity, they cannot search your house. That is a component of privacy. But that component was not violated in this case. Nobody busted into anybody's house without a warrant. Right? So, why does that amendment's shadow cover something broader? Right? And why can't Justice Douglas make up his mind about, which provision of the Constitution is the key provision. He's talking about too many different provisions of the constitutional text. They can't all be relevant. Justice Harlan writes a concurring opinion in this case, which is usually described as much more persuasive than Douglas is. And Harlan says, I'm not messing with those penumbras and emanations of the Bill of Rights. That there is one key provision of the Constitution that is relevant, and it is the word liberty in the 14th Amendment. That is the one that's relevant here. No state shall deprive you of liberty without due process of law. He cites earlier cases like Pierce versus Society of Sisters and Meyer versus Nebraska. He says, look, we've extended this to parental decisions about the care and upbringing and education of their children. We think the same we extended it to procreation in Skinner. He cites that one. We think the same kind of consideration covers the right of a married couple, that's how Harlan puts it, the right of a married couple to engage in consensual sexual activity in the privacy of their own home without interference by the state. That is what Harlan says. He even says, I'm not talking about abortion, I'm not talking about homosexuality, I'm not talking about fornication, I'm not talking about what single people are doing. He says all that in the opinion. He's like, but the right of a married couple in the privacy of their own home to engage in consensual sexual activity without the government interfering, that is protected by the 14th Amendment guarantee of liberty, Harlan says.
Did any of the states try it? Like, did Connecticut just be like, all right, we'll let married couples buy condoms?
Yes, well, yes. So another case comes back to the court called Eisenstadt versus Baird. I think this one's from Massachusetts. And Massachusetts said it was illegal to provide any information about contraceptives to a single person. Right? Not just handing them a condom, but like handing them educational materials about contraception. Cannot be lawfully provided to anybody who is not married, because of course nobody who is not married should be engaging in sexual activity, right? That's the state of Massachusetts is saying in the 1960s. The court strikes that one down too, and that requires the court to extend the principle of Griswold, right? Because both Douglas and Harlan in Griswold itself emphasize that they're talking about a married couple here, right? Obviously married couples are supposed to be having sex, right? And if they want to not get pregnant, they should have that right. So that's what we're protecting here. Remember, the court moves one case at a time. They usually try to craft their opinions narrowly to take one step at a time. You protect the right to use contraceptives for a married couple, and then some single people come to court and say, well, do we have the same right or not? And then the court's like, all right, yeah, you got that right too, right? In Eisenstadt, Justice Brennan writes the court's opinion. I think I got a quote from Brennan here. If the right of privacy means anything, this is in 1972. If the right of privacy means anything, it means the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. Right? So in Griswold we just said married couple. But we say this right applies to anybody, married or single. If the right of privacy means anything, it means the right of the individual, married or single, to be free from unwarranted governmental intrusion, and then check the rest of the phrase, into matters so fundamentally affecting a person as the decision whether to bear or beget a child. That obviously has some relevance for abortion too. Right? The decision to terminate a pregnancy is another way of saying the decision to decide whether you are bearing or begetting a child. Right? They're building on these precedents one step at a time. Griswold says a married couple has the right to use contraceptives. Eisenstadt says a single person or a single couple has the right to use contraceptives. Roe versus Wade says a pregnant woman has a right to terminate a pregnancy. Those are three different decisions, three different questions the court has to decide, but they are obviously connected to each other, and the court is building on the precedents one step at a time. These decisions are not without controversy, right? None of them are unanimous. Justice Black writes a dissenting opinion in Griswold, which is in the reading and well worth reading, right? Justice Black, remember, make no law, shall me make no law. He's famous for his strong advocacy of the First Amendment, although even there we saw some cases late in his time on the court where he seemed to veer from that a little bit. But Justice Black is on the court for like 40 years, and he's famous for emphasizing that the court has to stick as strictly as it can to the literal words of the constitutional text. The literal words of the constitutional text compel him to be very protective, most of the time, of freedom of speech. The literal words of the constitutional text compel him to be not very protective of the right to privacy, because the freedom of speech is in the constitutional text and the right to privacy is not in the constitutional text. I like my privacy as well as the next one, Justice Black says in Griswold. I like my privacy as well as the next guy, but I am nevertheless compelled to admit that government has a right to invade it, unless it is prohibited by some specific constitutional provision. Right? I'm not saying I like this Connecticut law. Stupid law. I don't like it. I wouldn't vote for it if I was in the Connecticut legislature. But that's not my job. My job is to enforce the literal words of the constitutional text, and that's not what we're doing here. Right? I realize that many good and able men, this is still Black and Griswold, I realize that many good and able men have eloquently spoken and written, sometimes in rhapsodical strains, about the duty of this court to keep the Constitution in tune with the times. The idea is that the Constitution must be changed from time to time, and that the court is charged with the duty to make those changes. For myself, I must with all deference reject that philosophy. The Constitution's makers knew the need for change, and they provided for it, and the place that they provided for it was Article 5, which tells you how to amend the Constitution. If you want there to be a right to privacy in our Constitution, you should amend the Constitution and put it in there. This is the same thing that Justice Powell said in Frontiero versus Richardson, when he's like, wait a minute, why are we protecting gender equality under the 14th Amendment? There's a whole constitutional amendment debate going on about whether to put gender equality in the Constitution. That's how you should do it. Same thing Justice Scalia says 20 years later in the VMI case. Right? Why is the court protecting gender equality under the Constitution? It's not even in there. If you want that to be in there, go ahead and amend the constitutional text. That is the way you're supposed to change the Constitution. But none of those arguments, Black, Powell, Scalia, none of those are in majority opinions. Right? A majority of the court, over and over again, has said, when we're talking about abstract language that is in the constitutional text, like no state is allowed to deprive you of liberty, right? What the heck does that word liberty mean? That is an abstract philosophical concept. It is our job to try to figure out what it means in any particular case, and I'm pretty sure our answers to that question are going to be different in 1900 and 2000, right? Like, why are we going to give the same answers they gave back in the mid-19th century? Why would we be expected to have the same conception of liberty that they had back then? That doesn't make any sense. Right? Over and over and over again, the court says, our job is to apply these abstract principles as best we can, and the particular kinds of things that they get applied to is likely to change over time. Right? Justice Harlan, who writes the concurring opinion in Griswold, Justice Harlan has a long part about this, where he's like, yeah, we don't just make stuff up as we go, right? It's all about our nation's legal traditions. Those traditions are evolving. They change over time. Sometimes we even break from some traditions that we used to have, right? But sometimes we build on our traditions and try to maintain them and continue them going forward. And that's what we're doing here today. Just like we protected parents' rights to control the care and upbringing of their children in Pierce versus Society of Sisters, and just like we protected the right to procreate in Skinner, now we're extending that same legal tradition to protect the right of a married couple to use contraceptives. And Harlan thinks, in his head, like, okay, and I'm not talking about homosexuality, right? He says that in the opinion, right? That is not included in this tradition. But of course, fast forward 20 years, right, and gay rights advocates are going to cite these exact same precedents and be like, yeah, that tradition is still evolving. You cannot criminalize private consensual sexual activity between two people of the same sex, which most of the states did. You can't do that. That violates the same right to privacy that we were talking about back in Griswold, right? Harlan is not there in 1965, but the evolving legal traditions that he's talking about, those traditions outlive him, right? And we will look at some cases in which they get extended to LGBT rights. On the abortion question, in particular, we will also look at some additional post-1973 abortion cases. And here's what's going on in those cases. So, in cases that come after Roe versus Wade, there's three possible kinds of questions the court might be asked to decide. One, was Roe versus Wade wrong, and should we reverse it? The court repeatedly gets asked to decide that question. And so far, the court has never said yes to that question. Right? It has continued repeatedly to reaffirm the basic holding of Roe versus Wade. Even though lots of presidents have criticized it, lots of state legislators, lots of members of Congress have criticized it, lots of new judges have been added, some of those judges themselves have been very critical of it, they still have never overturned it. A second kind of question the court gets asked in abortion cases after 1973 is, well, okay, so maybe we're not going to reverse Roe, but like that trimester framework, is that like a central part of it? Is that really the best that we can come up with in the effort to spell out the details for how we're going to balance the woman's right to terminate a pregnancy against the state's interests in protecting potential life of the fetus, right? The trimester framework, is there something wrong with that? Should we get rid of that or modify or change it in some way? And then the third kind of question that comes to the court is whether it's under the trimester framework or under some newer kind of balancing approach that the court might come up with, is this particular kind of law allowed? Right? Most of the time nowadays, state legislatures and Congress do not try to ban abortion altogether. Remember, Texas in 1973 had a complete criminal ban. Doctors could be prosecuted subject to lengthy prison terms. Complete criminal ban on abortion. The only exception was for pregnancies that immediately threatened the pregnant woman's life. Right? For the most part, nowadays, states do not try to enact laws like that because those laws are obviously unconstitutional, and the federal courts will quickly strike them down, and it's a waste of everyone's time and money, and like, what are we doing? What? They already told us multiple times. That law is not allowed. States occasionally still try to do it. They're like, oh, let's test it. Let's see if the courts are going to say anything different now. We'll try it. But mostly that's not what they do. Mostly, state legislatures that have concerns about abortion pass different kinds of regulations on it. Right? Not bans, but regulations. And Justice Blackmun's trimester framework, modified by some subsequent decisions over time, the court changes it up a little bit, but that basic idea to say we've got to figure out some way to balance the woman's right under the Constitution with the state's interest in protecting the potential life of the fetus, that has led to case after case after case where the states come up with a new kind of restriction on abortion, and the courts have to decide whether this one passes muster. We'll look at some of these cases later, but I'll just give you a couple examples and try to think about how they would fit with Blackmun's opinion. Some states have passed laws that require teenage girls who are pregnant to get their parents' permission. These laws come in multiple different forms. Some of them have required both parents' permission. Some of them require permission of one parent. Some of them didn't require the parents' permission, but they did require proof that you had notified your parents. Are those constitutional or not? Some states have passed laws that say if the pregnant woman is married, her husband has to agree to the abortion. Is that constitutional or not? Some states have passed laws that say if you show up at an abortion provider and say that you would like an abortion, that starts a clock, and then there's some legally mandated waiting period before you're allowed to have the abortion, right? So sometimes it's 24 hours, sometimes it's 48 hours. At least one state that I know of passed a 72-hour waiting period. So you can't show up at a clinic and get an abortion. You have to show up at a clinic, say you want an abortion, and then come back some specified number of days later. And those laws are usually combined with there's state-mandated information that the provider has to give you, right? So when you show up the first time, they say, okay, we can perform the abortion 2 days from now, but first you're required to review this information that the state tells us to give you. And sometimes it's straightforward medical information about the risks of the medical procedure, like with any other medical procedure. Sometimes it's information about alternatives to abortion, like here are some resources regarding adoption that you could contact. Sometimes it is medical information that, according to reproductive rights advocates, is false. Like sometimes the abortion providers are required to give you information saying that there is evidence of increased risk of breast cancer associated with abortion, which virtually all mainstream OBGYNs say is not true. But some states have required that information to be provided. Is that constitutional or not? Some states have imposed restrictions on who is allowed to perform an abortion, right? Only physicians, only MDs can perform it. There are some outpatient surgeries, minor surgeries that are performed by non-MDs, right? Other kinds of healthcare workers. Some states say only physicians can perform the abortions. Some states have passed laws restricting like where abortions can be performed. Right? So like public hospitals not allowed to perform them. Some states requiring them to be performed in hospitals, right? They can't be performed in a standalone clinic, or if it's a standalone clinic, it has to meet all these detailed regulatory requirements, like it's things like it has to be like qualified as like an ambulatory surgical center, which just might impose significant requirements on the size of the clinic and what kind of medical resources and staffing they have on hand. Even for first trimester abortions, which are routine procedures, often not even surgical procedures, right? No incisions of any kind made. Some states have passed those. I know I'm forgetting a couple categories, but that's a good list, right? There have been subsequent Supreme Court decisions about all of those kinds of laws where the court is called upon to decide whether are we sticking with Roe versus Wade, are we sticking with Blackmun's trimester framework in Roe versus Wade, and is this particular law allowed under that framework or not? And we'll look at some examples of those. The last thing I want to say about the abortion cases is just think of them again. So today we've been focused kind of narrowly on the court's opinions, but remember that all of this has taken place in a kind of broader social political context, social movement context. Last time we were talking about the women's movement in the 1960s, and that is, of course, the movement out of which reproductive rights advocacy emerges as well. And so just kind of last piece of this story to just think about, if you are a reproductive rights advocate in the 1960s, or if you are an advocate for any kind of rights at any point in time, right, one of the things you have to think about is, well, what is the most productive strategy for pursuing these rights? And in the U.S. constitutional system, you have lots of options, right? Am I lobbying my state legislature to change the abortion laws? Am I lobbying Congress to change federal abortion laws? Right? Am I going out and having public protests to object to our current abortion laws? Am I writing letters to the editor? Am I trying to get on TV, right? Trying to raise money and put some ads on TV? Am I going to court? right? That is one of the options that is available to you. And the reason that reproductive rights advocates, like Ruth Bader Ginsburg and the advocates of gender equality, in the cases we looked at last time, the reason that they go to court is that progress in all other arenas seems quite slow, at best, right? Usually, going to court is not the first resort, right? Reproductive rights advocates have been lobbying state legislatures since the early 1960s. 4 states had decriminalized abortion, one of which was New York. There was a major backlash in New York. The Catholic Church was very opposed to the new law. They were lobbying legislators really hard. And the New York State Legislature in 1972, I believe, voted to reverse the repeal of the criminal abortion law. They voted to repeal the repeal and recriminalize it. The governor in 1972, Nelson Rockefeller, vetoed that second law, right? So it stayed decriminalized in New York, but barely, right? The legislature had switched gears. And remember, that was one of only 4 states that had actually decriminalized it, and that one almost backtracked. And so reproductive rights advocates are like, we're getting nowhere, right? We got 46 more states, and we're like barely holding on to these 4. Like, could we persuade? Does the principle, the constitutional principle that the court adopted in Griswold versus Connecticut and Eisenstadt versus Baird, does that cover the right to choose to terminate a pregnancy? We think it does. Let's see if we can persuade the Supreme Court of that. And they do, right? And so that decision is partly about, what do judges decide about the meaning of the Constitution? But it's partly about the conscious, strategic, political decisions of rights advocates to push a particular constitutional issue at a particular point in time, right? And that's often because they are not getting anywhere via other political channels. And so we're going to see more examples of that, too. We'll stop there.